You may proceed.
Thank you, Lords. Lords, to deal with the remaining aspects that we want to cover, perhaps just to make sure that it's not taken too much of the Lord's time, given the else still have to be heard today. Can I take the Lords back to what Mr. Katz had said when we started dealing with what he called the main application? He made the point that once His Lordship Justice Davis's judgment withstood the scrutiny of the Supreme Court of Appeal, effectively by the dismissal of the application for leave, the only issue remained what now, as he had put it at that point. And perhaps if we can pick up with what we say the answer is there. Three things must now happen, given the further developments that have taken place, even in this court over the last few days and yesterday. The ad hoc portfolio committee will conduct its inquiry. If the review succeeds, which apparently it will, given what the SABC stance is, a new disciplinary inquiry has to be held, and the review of the Public Protector's report must be finalised. Those are the things that must happen. And what we have in this application is the DA trying again what it did not succeed in obtaining from Justice Davis. Can I ask you, Lords, to perhaps look at page 37 of our heads? It's perhaps just easier to go there than to the whole of the judgment. In paragraph 102 of our heads,
Paragraph 100.
Paragraph 102, that's page 37 of the heads. The bottom of page 37, paragraph 102, and what I seek to direct the Lord's attention to are the two paragraphs quoted there from the Davis judgment, paragraph 52 and 53 of that judgment. The essence thereof is, and perhaps it's more prudent to simply go directly to paragraph 53. Much has been made by the respondents of Mr. Motsoeneng's achievements at the SABC and his unique ability to be the COO of the SABC. If it is properly shown that none of the allegations made against him are sustainable, it would be unfair and hence premature at this stage to preclude him from such consideration, because in the previous paragraph the point was made that there's nothing that stops him from actually reapplying for that position. His Lordship continues, in summary, it is preferable to allow the relevant disciplinary proceedings to run its course and to reflect these findings in the order. And then he pointed out that he agreed with Mr. Manechi that that is the prudent course of action. So already at that stage, the DA sought an order that the SABC had to appoint a new COO within 60 days. Fill that post before the disciplinary inquiry had taken its course, was the effective point. And Justice Davis said, you are jumping the gun. That process must take its course. That is what the Public Protector said must happen. And it must be complied with.
Yeah, can I ask you this? Now, pending the review application that's in the Gauteng High Court,
yes,
and pending the disciplinary hearing, what must happen with Mr. Motsoeneng, according to you?
He should remain where he is. There is no basis to terminate his employment pending the outcome of those proceedings. And that is essentially what the DA wants.
But that could be, that's a different question from saying that he can occupy a senior executive post. One might say that nothing has happened to date which entitles one to say that he is not he's not entitled to his employment benefits.
Yes.
But the question is, should he continue to occupy a senior executive post while the public protector's findings stand?
Well, Lords, perhaps I can answer it in this fashion. There are two elements, and I think it's the essence of what you are putting to us. He's an employee, and that relationship, we submit, must continue, because there's no basis to terminate his employment when that is the very type of thing that the new disciplinary inquiry has to engage in. It effectively prejudges the outcome of those proceedings, and it effectively makes it lip service to have that inquiry, which is a requirement in terms of the public protector's report.
Well, let us assume for purposes of your further submissions this morning that Mr. Motsoeneng's employment relationship hasn't been terminated and that this court won't terminate it. I'm not saying that's going to be the decision, but I think to focus on the points that trouble us, it would be better to assume that he, until something more happens, is entitled to receive his employment benefits.
Yes. So, my Lord, then we say the answer must really come from the SABC, of course, because that made the decision to appoint him. But as far as Mr. Motsoeneng is concerned, you must keep in mind that the decision to keep him in the current position as a general executive is a decision that the SABC had to take in the context of conflicting requirements placed on the SABC. There's the requirement...
Sorry to interrupt you, but
yes,
can't that be a rational decision having regard to the public protector's report that's still standing?
That is the point I'm seeking to address, my Lord. So if my Lord will allow me to explain what we say about that. The SABC has to, at this stage, pending finalisation of these issues, consider various obligations it has. It has obligations to fulfil its mandate in terms of the Broadcasting Act. It has its obligations to comply with the Public Protector's report. And it also has its obligations as employer in terms of the Labour Relations Act and other statutes. So the confluence of these various requirements, it has to balance. And it has to balance it pending the final determination of the matter, by virtue of the outcome of the new disciplinary inquiry and the review of the Public Protector's report. So to the extent that it then decides internally, this is where we will utilise Mr. Motsoeneng. It can't be said to be irrational, because we must keep in mind that it is a matter of exercising a particular power, and I use the word in perhaps a bit of a loose sense, to utilise means to obtain a result. So, if one has regard to what that aim is, that result is, it is not irrational to say, well, we keep Mr. Motsoeneng in a position where he can be of use, but where he does not rule the roost.
That's not strictly, at least, how the SABC now explains its decision. It doesn't say that we balanced various factors, that we knew for the moment Mr. Motsoeneng was tainted by these findings which haven't been set aside, but on the other side we're going to have to pay him a lot of money, so let's rather use his skills as best we can. They say the effect of the final SCA's dismissal of the appeal against Davis J's judgment was that Mr. Motsoeneng automatically occupied this position. Now that's something that Mr. Du Toit will argue in due course, presumably. But the SABC doesn't advance this balancing exercise which you talk about. And, but in any event, putting it that way, the question is it rational? We have many instances, unfortunately. One might say, rather, if a judicial officer behaves in a certain way, and there have been recent examples, do we say, well, rather than not utilize their judicial services, we will have such a person continue to serve on the bench while these allegations are unresolved? The answer is, unfortunately, we do not want that. And the fact that one has to pay a lot of money for a long time is an indictment of how poorly disciplinary processes are run. It's not because the solution is wrong.
Yes.
Can I just add to what my learned brother said? So the issue comes down to the fact that such a person remains suspended pending resolving all the outstanding issues.
Well, let me perhaps just go back one step. It remains for the SABC to explain that decision, because it's not a decision made by Mr. Motsoeneng. So what we are simply saying is, it is not merely irrational for the sake of having been made. It's not as simple as saying, well, he's in that position, that's irrational in the circumstances. What we are saying is there's a bigger pot to consider.
Yes, but in considering that bigger pot, you see the issues here, some serious adverse findings been made by the public protector against your client.
Quite correct. What we are saying is simply this. That's not the only factor. And a decision to utilize him in a particular capacity, whether that's because he reverts to that position or whether he's newly appointed in that position, doesn't really take away from this point.
In fact, if the SABC had had its way, the way they would have utilised him was to continue acting as its chief operating officer. It was only the minister who said no.
Well, that seems to be the case. But of course, again, that is not a decision by Mr. Motsoeneng. But it does show that they want to utilise his skills. So the only submission we're making on this point is this. It may be that it is thought that there are better decisions to be made, but that of course is not the test. It is whether the decision that was made is one that is in that pot to be considered. And what we are saying is it was one, and therefore it can't be said to be irrational. That is the simple point that we advance on that aspect.
Mr. Bester, sorry. For some reason I had Barlow in mind, but he featured somewhere in the ancient history of this case. I'd meant to raise it with my colleague before we came into court, but can I just throw out this idea, and it goes back to the delay in resolving what everybody now seems to accept will be a new disciplinary process. We don't have a quorate board, and the public protector's remedial action was directed at the board's appointing a disciplinary chair and prosecutor.
Yes.
Just occurred to me that a resolution might be for the interested parties, which I would take to be the SABC, your client, and the public protector. I'm not sure the DA should necessarily be involved in this. If they between themselves could agree on the identity of a suitable chairperson and prosecutor, and then the public protector who previously recommended something else might consent to the court directing the appointment of a particular chairperson and prosecutor, so that the process doesn't have to be delayed while the board is reconstituted. I don't expect you to answer it.
Of course, we will take instructions. I do agree that there is no good reason for the DA to be involved in that process. It comes here on behalf of the public.
The minister's attorney in council might also have had a say into that.
That's correct. It's rather the minister than the DA who may have to be involved in that.
That's why we exclude the DA.
No, of course. I'm simply agreeing with the bench, as it pleases the board. If you will just allow it, seems that I have instructions.
Of course.
Thank you. My apologies. Lords, thank you for that. We will just have to take instructions from our client and advise him appropriately. It's not so easy to do it.
We accept that.
We will do that a bit later if you will allow us. Lords, if I can then go back to where we were. We have a situation where the relief being sought here seeks effectively, and this is where we left off before we started this in-between debate, where this application effectively seeks to preempt the outcome of the review as well as the disciplinary proceedings. It also is a second bite at the cherry because, His Lordship Mr. Justice Davis said, wait for the disciplinary hearing, wait for the outcome thereof. Now the DA comes to court and say, no, well, we're not willing to wait. We successfully review the disciplinary inquiry, but we're not willing to wait for the outcome thereof. We want this court to now effectively make a decision that will bind that disciplinary inquiry. Make it lip service to the public protector's steps that she stated must take place in the report. But the DA now seeks to go further than that. And that is what Prayer 1 is all about. Not only do they want to revisit Justice Davis's indication that they should wait for the outcome of the disciplinary inquiry, they say, well, also for other positions. It's a necessary consequence of the factual findings of the public protector, that it can't be in any other position. Now,
Mr. Bester, can I ask you this on that score,
yes,
regarding to the review application? Absent the DA's complaint regarding the review application, the situation would have been de facto and de jure that Mr. Motsoeneng would have been discharged, or he would have been found guilty of all the complaints against him. Is it correct?
well, my Lord, we're not so sure at this stage that we can commit to an answer to that. It's not an issue before, my Lords. And we've heard the public protector's interpretation of what should happen there, which differs slightly from what we've previously understood to be the situation.
Can I ask my question again to you?
Yes, Lord.
Absent the DA's complaint, the review proceedings, in terms of the inquiry that took place, that outcome would have stand.
Oh, I apologize, I misunderstood. Yes.
Now the DA comes to court and complain about it. And now it appears everyone else that was involved in the discipline inquiry now says, oops, yeah, there was a mess up. He didn't comply fully with the principle of legality, and therefore we agree it should be set aside.
Well, of course, it's not everybody in the true sense, in the sense that Mr. Motsoeneng simply says, well, it's not my inquiry to organize and to run and to arrange.
Well, the SABC board comes to court and says, listen here,
Yes,
we didn't comply with all that was required from us.
quite correct.
And it appears that the minister also to some extent, no, sorry, I apologize.
Well, Lord, yes, the SABC comes to court and say, we now agree that those proceedings were not correct, and therefore, essentially, they concede to the review, as we understand it. And that's the status there. So they will, from the perspective that we have, it seems that it's unavoidable that there will be a new review. But of course, at the time, the way to deal with the public protector's report was understood in a certain manner. And the fact that that subsequently turned out to potentially be wrong doesn't change the fact that it happened. It doesn't per se mean that everyone involved had malafide motives. It also certainly does not mean that Mr. Motsoeneng had a hand in it. He was simply the employee.
Well, according to the argument put up by the DA, they say that if you have regard to the people that's on the board, the 9, that took the decision, who should be the initiator, who should be appointed, Mr. Motsoeneng's name appear on that list.
But my Lord, with respect, it's denied, and that is an inference, and we know the test for inference. It is not the most probable inference. My apologies. Yes. And it was be seen in this context. He was on special leave at the time. On the facts known to the court, the better inference, the more plausible and probable inference, is that he did not participate and that it is simply a mistake on the document.
So then the board was incorrect.
We have to accept that. But again, Mr. Motsoeneng was not there. He didn't participate in that. It can't be laid at his feet. Okay. And that may very well be part of the reason, we will wait for Mr. De Tooy, why the concession had been made regarding the review of the disciplinary inquiry.
You see, the only point that is being made, it appears that there's the DA is being said that they come to court unnecessary. They come to court with matters that should be dealt with outside. But here with the review application, it appears on what we've got in front of us now, their complaint is a result that very disciplinary hearing is now being set aside. And it appears the employer of Mr. Motsoeneng comes to court and say, mea culpa. You know,
Yes,
we made a mistake.
quite correct, Lord. But of course, it doesn't mean because the DA is correct in one application, it must be correct in another application.
No, that's accepted.
But what we do know is that the board, subject to Mr. Toy's argument that everything happened by operation of law and that there wasn't actually a decision to appoint your client to the current post, your client, assuming there was a decision, made its decision to appoint Mr. Motsoeneng to the latest position and to reshuffle Ms. Togwana, knowing, already taking the view that the disciplinary inquiry was not proper compliance with the Public Protector's order, because they'd already taken that view and instituted the Gauteng proceedings.
Yes, we'll have to wait for Mr. Toy, but on the face of it, it seems to be correct if the law puts to be yes. But what we are saying, we're not attacking that process, because I explained yesterday that Mr. Motsoeneng does not take issue with that. He stayed out of that, apart from putting up facts explaining why he feels prejudiced. But what we are saying is, as a consequence thereof, the relief sought in the second application before the Lords should not be granted, because it preempts the outcome of what must now be the new, properly done disciplinary inquiry.
Yet I'm sure neither you nor I want to keep on repeating questions and submissions,
Yes.
but I'm not sure yet I have an answer as to why, assuming in 3 months' time there is a new disciplinary outcome
Yes.
which clears Mr. Motsoeneng properly
Yes.
of all charges, do you say that that will render rational the decision that was made in September?
No, we're not saying that.
But then why should we wait for that outcome or any other outcome? If it's an historical fact, it was either a good decision when it was made or it wasn't.
We are concerned principally when we make that submission with Prayer 1 of the Notice of Motion. Prayer 2, the setting aside of the September decision, is principally something that the SABC must explain. And we only made the earlier submission regarding the balancing and that it is not an irrational decision in the context. And I don't want to repeat that. That's all
But
we
assuming we don't agree with the width of Prayer 1 in the Notice of Motion, if your client, it seems, cannot properly be appointed an acting COO, it is said he doesn't have the skills to be the Group Executive of Human Resources, I think was a potential opening for him, and if his appointment in corporate affairs is set aside, realistically,
Yes.
there isn't going to be another senior executive position for him to occupy until either the Public Protector review succeeds or a new disciplinary inquiry clears him. I appreciate it's a matter of you don't want the order even if it's not of practical effect, but am I right that it is unlikely to be of practical effect if Prayer 2 is granted?
Probably yes. But what we are saying is Prayer 1 asks very different relief. Apart from this, and perhaps I should just point it out, perhaps it's appropriate to at this point just ask you to have regard to the wording of Prayer 2. And you can also find that at page 3 of the papers. Because there are actually two parts to Prayer 2.1. And the first part actually repeats Prayer 1. Because the first part says, it is declared that the decision to employ him at all. So that's really a repetition. So if we talk about our submissions regarding Prayer 2, it's really about that part, the particular appointment in that particular position. Because the first part we say shouldn't be part of Prayer 2 at all. It's a repetition of 1.
Oh, that's right. I can see that.
So if we then just focus on Prayer 1 for the moment, because that's really where the balance of our submissions go. The DA wants a declarative that the court, that Mr. Motsoeneng may not be employed by the SABC at all. It therefore seeks to terminate his employment relationship. That's what they ask. Whether or not he should continue as an employee is something that will be decided in the disciplinary hearing. So it can't be circumvented that this relief seeks to preempt the outcome of the disciplinary inquiry. This is not about what position he deals with in the interim. This is not an application for his suspension pending the outcome, to take him out of the fray or anything of that kind. That's not the case we have been brought to court to answer. The case we've been brought to court to answer is a declarative that Mr. Motsoeneng cannot be employed by the SABC.
No, but that's not entirely correct. It says here, unless and until all the negative findings against the first respondent in the report of the fifth respondent, being the public protector, are reviewed and set aside by a court.
With respect, my Lord, it makes no difference. If his employment is terminated, it's terminated.
I think we do, though, have your submission on the point that nothing that's happened in law to date has terminated the employment, and that it wouldn't be appropriate at this stage to, as it were, declare that he isn't an employer and can't be an employee.
Well, my Lord, there's nothing further to Prayer 1 then, with respect.
That may be. It's not the whole case, but it's. Either way, I think we have your submissions on this point, and it's probably, if I may respectfully say, not the DA's strongest point. This relief, Prayer 1.
Yes.
The idea that they can't have him at all. If by that you mean that they can't recognize him as still being an employee and recognizing his employment benefits. For the rest, it seems to be not of practical significance, because if his appointment as the corporate affairs executive is set aside, there doesn't appear to be any other position into which he could plausibly be placed, pending the finalization of the review or the disciplinary proceedings. I mean, we wouldn't necessarily have to say that, but it just doesn't appear to be a live issue.
Yes, Lord, yeah, that's not an issue that is to be found. And whether or not that is the implication is not really the issue before this court and ought not to be determined at this point. The way in which the SABC deals with Mr. Motsoeneng in the event of this court setting aside the September 2016 decision is not what has to be decided here. But it creates a difficulty if that's done in the context of what is asked for in Prayer 1. But if that appointment to a particular post is set aside, then he remains an employee. And then the SABC must make decisions as to how to utilize or not utilize him until the outcome of the disciplinary inquiry.
Well, that's why it was alluded earlier that in certain circumstances, persons are being suspended with full benefits pending the outcome of the inquiry.
Of course, that is so.
I mean, to give an extreme example, one might say, well, there'd be no harm in Mr. Motsoeneng being services being utilized as a cleaner pending the outcome of the review or disciplinary proceedings. But that would be demeaning to Mr. Motsoeneng, and it's not going to happen.
Yes.
So we're talking about his occupying senior executive positions.
We are, but the important thing for us is that it is recognized that he is still an employee of the SABC. That can't simply be terminated. That is the real issue.
Can I just mention something, and it's a point I'll for Mr. Du Toit also to think about. It's not directly raised on the papers, but I think Mr. Aguma says that once you get to these high, I think the general executive positions, they're 5-year contracts. And we have Mr. Motsoeneng's current contract following the latest appointment.
Yes.
If the position is that by setting aside the appointment as COO, he simply reverted to his previous position, and I think the evidence is that the current corporate affairs position is simply a renamed version of a job he previously held.
That's good.
Well, he was appointed to that position in April 2011. And if that was a 5-year contract, didn't it expire in April 2016? And these contracts say there's no expectation of renewal. I raise it for consideration because there appears it appears that once you, as it were, take on the high-profile jobs with the big money, that comes with it the idea it's a fixed-term contract and you have no right and no expectation to re-employment.
That is correct. We accept that that's the
So
principle.
if there was no valid decision after the decision to appoint him to what was then called, well, let's just call it the corporate affairs position, it had a different name, in April 2011, it seems to be a misconception to say that, it may be a misconception to say that he was still an employee if that argument is that he just reverts to his previous post.
No, my Lords, with respect, he remains an employee. The fact that he's appointed to the one or the other position doesn't change the fact that he remains an employee.
Yes, but on the SABC's papers advance, it is when, as my learned colleague just indicated, you get employed for the fixed period of 5 years. There's no guarantee of re-employment. So, if the argument holds that he remains an employee, he would revert to his old position, which was a fixed 5-year period, which would have expired in April of this year.
It may be something not sufficiently canvassed on the papers because we don't have, I don't think we have in these papers, we may, I haven't seen it, the April 2011 contract. But it may be something that, if it can't be considered on these papers, does need to be investigated because the SABC may be acting under a misconception.
Yes, my Lord. Can I just take instruction before I make my two submissions?
Yes, of course.
Thank you. Firstly, with respect, we agree that issue is not canvassed on the papers. And it is extremely prejudicial for Mr. Motsoeneng to be faced with this beyond halfway through the hearing, where the matter has not actually been canvassed at all on the papers. But secondly, assuming it would have expired in April, he continued. And that by itself, as a matter of contract law, keeps him an employee.
But what he continued as was COO.
Well, but he continued as an employee. Because we can't have half the one argument and not the other half. Because if we say he reverts to that, he remains an employee, and they keep him beyond April, whether they're incorrect about the position or not. The fact is he has continuous employment with the SABC. So then we would submit, and the issue has not been canvassed. It is not as simple as to say, well, it is terminated, because it really creates a different set of facts to consider as an academic aspect almost, because it does not accord with reality. One must keep in mind the facts of how things actually unfolded before one considers what should be the status of that question.
But let me bring you back to the point that you've raised earlier. Do I understand you correctly that the point that you're pressing is, in terms of Prayer 1, what the relief the DA is seeking presently is that he may not hold any position at all?
Yes.
Which essentially means that if this relief is granted as it stands here, effectively terminates the employee-employer relationship that's presently in existence.
That's the essence of the point, yes. And that principally for two reasons. The one is it prejudges the outcome of the disciplinary. The other is it deals with his employment summarily without any consideration of his labour rights. And that's where the arguments in terms of Section 23 and to some extent Section 22 of the Constitution come in. And then we must consider whether Section 36, the test in Section 36, has been complied with. And then we must consider what is the law of general application that the DA contends is reasonably and justifiably limiting these rights.
Mr. Bester, with an eye on the time,
Yes.
I think you continuing to fight a fight which you may in any event succeed on. I don't want to cut you short unnecessarily.
Of course.
And obviously we haven't decided any issue. But
of course, thank you. Then,
But your point has been made and it's been noted.
thank you. Then let me just make sure what we can then skip because we have only a few things to look at. Yes. Lord, if I might take
Yes, man.
Thank you, my Lord. Just briefly, and perhaps just to tie up a few aspects. There is a conditional application to stay. The basis of that is simply that in the circumstances now, to grant this relief in prayer 1, and it ties closely to the previous points that the Lord said we need not belabor, so I will be brief, just so that it's still in the mix. We say it's inappropriate to grant this type of relief at this stage, where it effectively preempts the outcome of other processes. And that is the purpose. So if the Lords do not find that the DA cannot at this stage succeed with that relief, then as a fallback we say, well, then at the very best, it is something that must be determined later, after the outcome of the disciplinary and the review of the public protector. But I don't need to re-argue the point, we will still simply stand by that. Briefly, because it might tie in with the issue of cost, there is a strikeout application. The only real point taken in respect of that notice is Mr. Motsoeneng did not specify the details of which specific allegation he seeks to strike out, in terms of which one of the various reasons why it can be struck out. Of course, that comes from the DA, who complained that service is a technical point. Yet they opposed that notice by saying, well, you actually haven't dotted the I's and crossed the T's within the time constraints. We do not want to waste this court's time with going through that process. It serves no purpose. What we do say is that the notice is well founded on the papers we submit, and that should be taken into account, if only in respect of the issue of costs. And lastly, then, if I can deal a bit more with the costs issue, we say that we've dealt with the cost in the review, so we're only dealing with the cost in the main application. Factors that must be taken into account in this instance is those initial aspects that we've raised regarding getting this matter before court, so that even if this court entertains the matter ultimately, those should weigh heavily in the court's mind when it comes to the cost of the application. And similarly, when we look at the strikeout and stay application. And so what we are saying, Lord, in conclusion, prayer 1 should not be granted. Prayer 2, we say, should also not be granted, but we've made limited submissions in that regard, and we'll leave the rest to Mr. Motsoeneng. Overall, we submit that Mr. Motsoeneng should not pay the cost of this application, even if the laws grant some or the other of that relief. Of course, in respect of the rest, it must be clear that that is not relief that he has hand in, and that where he should be bumped with the costs. So it's really those two that are relevant. And we submit with respect that these factors should weigh heavily against any cost order to be paid by Mr. Motsoeneng, irrespective of the outcome of the application. It will also allow me.
Yes, you may take instructions from you, Junior.
Lord, and perhaps just to finalize the point, goes to the cost issue, the strikeout issue. It really is inappropriate, where the case is built around factual findings that can simply be stated, and stated in the terms of the public protector, to then embellish and call Mr. Motsoeneng a Nazi. The greatest of respect, it is very offensive to be called a Nazi with all that goes around that. To, in the South African context, call a black man a Nazi is quite frankly something that this court should specifically and firmly address. Thank you, my Lord.
Thank you, Mr. Bester. Mr. Du Toit.
Would you please, my Lord? Lord, this case has taken a significant change. The complex of this case has undergone a significant change in the course of yesterday. That significant change is the concession by the public protector that a disciplinary inquiry or disciplinary hearing can come to different conclusions than arrived at by the public protector. Now, if that is the case, then the disciplinary inquiry should be held, and the results may differ from what the public protector has found. But of course, that's not the case that we came to meet here. The case we came to meet here departed from the basis that the findings of the public protector were written in stone. That is clear from the attitude of the Democratic Alliance, as expressed in its papers, and also clear from the attitude expressed by the public protector herself in her affidavits.
Well, I read through the affidavit to see whether, in fact, Mr. Labuschagne was adopting a position contrary to the public protector, and I don't think she, in fact, ever said that the disciplinary inquiry can't inquire into the merits and reach different findings. What she said was that the SABC could not conduct a parallel process with a view to finding contrary facts.
She said that as well, yes.
But she didn't. I had rather understood that, perhaps because the DA said it, that she meant that in the way the DA understood it. But it's not clear that she did.
Well, my Lord, perhaps we should look at the papers.
In which of the two applications?
Well, why don't we look at the one in this application, what is called the main application? I invite you, my Lord, to look at page, I think it's 979. Paragraph 8. Last sentence. The binding effect of findings made by the public protector, considered separately from remedial action, is particularly relevant in this matter. Then page 980. 980, my Lord. Oh, sorry, I seem to have two sets of numbering. Yes, it is 980, paragraph 10.3.
Yes.
It is 980, is it?
Yeah, I've got it.
Yes, thank you, my Lord. When remedial action is binding, compliance by the organ of state for such remedial action is not optional, whatever reservations the effective organ of state might have about its fairness, appropriateness, or lawfulness. It is not open to the SABC, the board, and the minister to pick and choose which of the findings, and I stress the word findings, and remedial action they will disregard. The next page, paragraph 11, the second sentence. However, such a process may not constitute a parallel investigative process to second guess and replace the findings and or remedial action. Next sentence. The purpose of such investigations will be to determine whether the findings and or remedial action will be challenged in a court process or not. Now, there's difference in view, obviously, in the light of the Nkandla judgment, that the findings can be set aside by a court in a review. But here, she has never conceded previously that the findings could be dealt with by a disciplinary inquiry. Now, she's been compelled to...
Well, I think your client itself initially interpreted the report as necessarily entailing that the disciplinary inquiry could, as employment inquiries do, go into the merits and sanction.
Yes.
So it wasn't self-evident from the report that the findings couldn't be departed from by a disciplinary inquiry. The SABC itself couldn't say, well, we're not going to comply with the remedial action because our parallel process establishes that Mr. Motsoeneng has done no wrong. But that's a different matter.
We're talking about your Lordship's point that the findings, her findings of fact, could not be differed from by a disciplinary inquiry.
Yes, now what she is here saying is what the SABC can decide, not what a disciplinary inquiry can decide.
Yes, here. But nevertheless, in the context of this affidavit, it is quite clear that she regards her findings as final.
But then what would be the point of directing that remedial action in the form of a disciplinary inquiry, unless it was clear that she said...
That is one of the dilemmas which the SABC faced and which we've dealt with in our heads of argument.
Well, it's a dilemma which arises on the interpretation that the disciplinary inquiry has to accept the factual findings. And,
yes.
and that presumably is one of your points in the Gauteng review.
Yes, I am not briefed in the Gauteng review, so I can't speak for that. What I find interesting is that both my colleagues in the Gauteng review and my distinguished juniors in this matter and I all misunderstood what the meaning of the protector's affidavit was. Apparently we were misled by something, but I'm not sure what. Can I refer you to paragraph 12? Insofar as the findings themselves are concerned, they stand unless and until reviewed. It's quite clear.
But Mr. Du Toit, if you have regard to paragraph 24, it also appears that what the public protector is saying is that the remedial action taken contemplated a fair and lawful disciplinary hearing. So when the disciplinary hearing hears the matter, it must still be a lawful and a fair hearing. Now, in having a fair hearing, surely whatever the findings that were made, to some extent, can be revisited by Mr. Motsoeneng, and he can put up evidence to show to the contrary.
Yes.
It must be in order to be fair.
I think the Lord must go back. What did the public protector say? She said appropriate disciplinary action.
Yes.
That has been interpreted by her in her affidavits, and also by her predecessor, if I may say so, as being a departure, as dealing with sanction only, not dealing with merits.
Well,
and that is the dilemma which faced the SABC.
Well, the question is whether that's ever been explicit. I must say that I was, if we can put it this way, misled in the same way that you and others were. But which
He's
is
speaking
why
for himself.
I'm speaking for myself. Which is why, in the light of what Mr. Labuschagne said, I went back to examine the affidavits, and I see it's not as clear as I thought. But I don't say that the way you've understood it is not how one might fairly have understood it.
Well, if one starts with the judgment of the Supreme Court of Appeal, which does say that the findings stand unless set aside in a review, and you have regard to what the Democratic Alliance says in their papers, and then you read what the Public Protector has said in her papers, the conclusion that the disciplinary action which was required dealt only with sanction and not with merits. It couldn't inquire into whether, in fact, Mr. Motsoeneng did or did not do what he said to have done. It dealt only with sanction. And that's the way, quite frankly, it's been interpreted till now. But we believe that the concession made by Mr. Labuschagne on behalf of the Public Protector is perfectly correct. It's correct because it then accommodates the Section 23 rights which Mr. Motsoeneng has. In other words, he's entitled to fair labour procedure. And that has been the dilemma. And that dilemma, in fact, Mr. Aguma refers to in his affidavit and also referred to in our heads of argument. We've had this problem. On the one hand, the Public Protector's findings are immutable, of fact. On the other hand, he's entitled to a fair hearing. How do you resolve that? A fair hearing cannot depart from a conclusion. In other words, you're guilty, now tell me what else you have to say. And that...
But having said that,
yes,
in saying that I came to a conclusion that you're guilty, but I give you a fair hearing to put up evidence, now you put up evidence and you show to the contrary. The suggestion here is that the chairperson of the disciplinary hearing can then make a finding on what's in front of him, but he cannot ignore the finding of the Public Protector. He's got a finding there, he's got new evidence here, and then he comes to a conclusion. And the conclusion is the disciplinary hearing's conclusion.
yes, one would think that if one
Isn't
has
that
regard...
part of a fair hearing?
If one has regard to the Section 8, I think it's called, of the Labour Relations Act, the code which is annexed to the Labour Relations Act. Schedule 8, sorry, Schedule 8. If one has regard to the disciplinary code which applies to the SABC, then you cannot start an inquiry, a disciplinary inquiry, with a finding of guilty, because then it's purposeless. And that is exactly what the DA wants. The DA wants the disciplinary inquiry to depart from the position that you're guilty. Now say something to us. Well, that we don't regard as fair, and we think that's a breach of his Section 23 rights, and that is, in our respectful submission, a irregularity in the Public Protector's report, because she's ignored the Section 23 rights.
Well, that assumes that she intended, or that on a proper interpretation of her report, the remedial action in terms of the holding of a disciplinary inquiry was to be a sanctions-only hearing. And I must say, having read both the affidavits successive public protectors have made in the first and second cases before us, it's not clear that she means that. She continually says the board can't second-guess my factual findings and, as it were, present watered-down charges. But her complaint, the way she associates herself with the DA, is not to say it's a sanctions-only hearing, but to say that because of its flawed approach to her findings, the SAB sabotaged the hearing by failing to pursue certain charges and failing to lead evidence. Now, she could only make those criticisms if it was permissible in terms of her report for evidence to be led on the charges.
My Lord, once again, can I refer you to her affidavit? Because I haven't ended my references to her reliance on findings.
Well, I was referring to her first affidavit because that is the one in which she was squarely dealing with the question of the disciplinary process rather than the appointment as corporate affairs executive. But it may be that the allegations are the same in both.
I'm going to come to the first affidavit in a moment, but can I deal with the second one, the one by the current public protector? In paragraph 13, she says, I set out the findings made, and it is the board and the minister failing properly to recognise such findings and give effect to such remedial action. And then paragraph 15. To date, neither the SABC nor its board has duly accepted the findings made and implemented the remedial action. Paragraph 16, the findings made against Mr. Motsoeneng are detailed in paragraph 10, and then she goes and sets out the findings. And then in paragraph 16.2, she says, Mr. Motsoeneng fraudulently misrepresented his qualifications by stating in his application form that he completed matric, and he continued to perpetrate this fraud. He again repeated his misrepresentation. Now, apart from the fact that the public protector doesn't seem to understand the difference between a misrepresentation and a fraud and a dishonest filling in of a form, there's clear distinction. The representee in a fraud cannot complain if he knows the truth. So, and that is what Mr. Kloppers at the previous hearing said. I knew what his position was. So she doesn't distinguish about that, but that's one of her findings. So in other words, she envisages that the disciplinary inquiry should depart from the position that fraud was committed. The fact that he filled in the form wrongly is admitted, and he's apologized for that. And that brings me to a point. What is the point of disciplinary hearings? It's not only to arrive at a dismissal. There are many results that can flow from a disciplinary hearing and a disciplinary inquiry. The approach of the Labour Relations Act is, and has been confirmed in our courts, in a judgment also by Judge Hlaudi in the Natal Labour Court. I may not be you, my lord, but it's...
Definitely not me.
But, well, we share the same problem. Lord du Toit is much like Hlaudi. There are many of them. But the aim is to reform and to discipline, and to cure is to make the employee better. So the outcome is not necessarily dismissal. But that is the result which the Democratic Alliance wants this court to arrive at, even before the disciplinary inquiry has been held. Can I refer you also to paragraph 16.3? The findings which are there, which are said to be indisputable. Paragraph 16.6, 16.7. And then in paragraph 17 at page 984, once again, she refers to the findings. What is also important, Lord, is to see what exactly the public protector wanted the disciplinary action to be. There were only 3 matters which he said had to be investigated, or not investigated, but dealt with, let me put it that way. One was the misrepresentation of his qualifications, and that's said in paragraph 20.2. The misrepresentation of his qualifications. Secondly, his appointment of Ms. Motsoeneng. And thirdly, the purging of senior staff. These are required disciplinary action.
But
not the rest.
She also mentioned abuse of power.
That's in relation to Ms. Motsoeneng. The abuse of power and improper conduct in the appointment and salary increments of Ms. Motsoeneng.
Mr. du Toit, I presume you will accept that the SABC can't approach this, or the board can't approach this, on the basis that we are going to do the bare minimum. And if we see that there are serious findings against Mr. Motsoeneng, but for some reason they haven't been captured in what she says the disciplinary action should approach, we will ignore them. That wouldn't be bona fide, would it?
I'm I'm not sure that I follow your point. She said
if she makes 6 findings, serious findings against Mr. Motsoeneng, and for some reason says the disciplinary action must deal with 3 of them,
yes.
do you think a board acting bona fide could decline to deal with the other 3? Or would that not reflect an attitude that we are going to do the bare minimum with a view to ensuring that Mr. Motsoeneng is not dismissed?
I'm not sure that this case deals with that, my lord.
Well,
this case deals with what the SABC should have done pursuant to the Public Protector's report.
But you're emphasising the point that this is all that the disciplinary action had to deal with in terms of the remedial action. I appreciate what the focus of this case is, but the starting point, that this is all we have to do, is symptomatic of what the applicant and the Public Protector say is the attitude of the board, which is not to be bona fide in dealing with these matters, but as it were to do the bare minimum. In other words, it starts out from the contention that Mr. Motsoeneng is a good executive who should remain.
Firstly, it's not the board that has to do this, it's the initiator and the independent chairman who will consider this matter. That's clear. But secondly, we can only deal with the case as it is on the papers. We can't now say that the SABC, and I don't act for the board, I act for the SABC. Let me make that clear, there is no board other than the chairman. The SABC can instigate or can bring about an inquiry, disciplinary inquiry, but the initiator must deal with it.
Well, it must at least comply with the Public Protector's report, but it must generally act bona fide. I mean, can I just raise one matter, because it's a point of concern. It rose after the Public Protector's report, but it's, for example, what Mr. Motsoeneng originally said about his attempts to contact Ms. Swanepoel, and the subsequent facts which have emerged about that, and what the SCA said about it. Now, if there's going to be a disciplinary inquiry, could a bona fide board refrain, for example, from including that? Because it doesn't have to limit itself to the charges that the Public Protector put in.
Well, Lord, I can't speak for the board, but what I can
Sorry,
say...
well, I speak with the board because generally that is the party. I speak of the SABC.
Yeah. It may be that the SAB will consider other matters as well. But certainly what it has to do is to deal with those 3 matters. That it has to do. And there's no question about that. But whether it deals with anything else, that's a different case. That's not the case we have to meet here. And
but the point
what your Lordship is postulating is a further DA application at some future state. No doubt.
Now, I think that
they like litigating.
Mr. Du Toit, I think the point that's being made is, if one have the bona fides and the SABC says, but this is what the Public Protector says, we are only limited to what's on the paper here. But if it appears that further information comes to the fore and transpire, then surely one would expect that a bona fide SABC or board will also include those matters.
Yes, my Lord, clearly. Clearly, there can be no doubt that when the board then exists, when it's reappointed by the President after recommendation by the committee, that board will certainly be able to consider whether further matter should be dealt with by an inquiry. But that's not the case we're dealing with here.
I mean, ultimately the end objective is to make sure that one has competent, honest, trustworthy people in top positions.
Well, yes, but that deals with a different question, which I want to deal with later, arising from a suggestion from Mr. Justice Rogers about rationality. But I'd like to deal with that in a different context, if I may. If I may just complete on the affidavit. In paragraph 23, what she says here in the case of these clear findings, indicating that Mr. Motsoeneng was not an appropriate person to be appointed to any position in the SABC. The SABC and the board appointed Mr. Motsoeneng as permanent CEO. Well, that of course is no longer the case, but once again I underline in this paragraph the word findings. So I would submit, and it goes on, it actually, if I mention, I'd like to mention paragraph 37, paragraph 38, paragraph 39. And this is really what she now contends. I am therefore advised and submit that the appointment of Mr. Motsoeneng in any position at the SABC, particularly a position of authority and leadership, would improper until such time as the SAB's application for a review has been finalized. For a review. So her attitude, as expressed yesterday, is a departure from what she says here.
I appreciate you're not briefed in the Gauteng matter, but this change of stance or your fresh understanding now of what the Public Protector actually says, how does it leave matters? Because to some extent it seems the board has, or the SABC, has taken the view that its disciplinary process in December last year was flawed because it assumed it included the merits. Now, it now appears that in fact it correctly included the merits, if subject to any stance that the DA or other intervening parties might adopt in the Gauteng review. Now, so the question is, do you want us to decide in this case that the disciplinary hearing is a merits hearing and a sanction hearing, or should that be left? Is that more properly left open to Gauteng? Because it seems now that neither you nor the Public Protector or the direct parties to the review in Gauteng will be arguing that the merits are excluded. But I'm not sure if we can exclude the possibility that somebody will intervene to say it's sanctions only.
Well, my Lord, as I understand the review, it is to set aside the findings of the Public Protector by a court, as required by the Nkandla judgment, as required by the Supreme Court of Appeals judgment.
But one of the main purposes of that, as the review is summarized in the papers before us, is that it doesn't allow the merits to be investigated in the disciplinary hearing.
Exactly.
And now that appears possibly to be a misconception.
Well, that's an interpretation. That's a concession made by the Public Protector. Whether that's correct in law or not, a court must decide.
And must be decided in this case.
Knowing what we know now.
If we're going to direct a new inquiry to be held, it seems to me that it's inevitable that one has to say what it can deal with.
In our submission, an inquiry, a proper disciplinary inquiry, having regard to Section 23 rights, having regard to the rights under Section 185 and 186 of the Labour Relations Act, must necessarily inquire into the merits.
There's no doubt at the level of labour law that is so.
Yes.
But theoretically, assuming the Public Protector's remedial action had said a disciplinary inquiry which must determine, on the basis of the accepted findings in this report, what sanctions should be imposed on Mr. Motsoeneng, that would be binding remedial action until it was set aside.
Correct.
Even if it would violate labour rights. But it might then provide the SABC or Mr. Motsoeneng with a strong case for review. So in any event, your contention is that the understanding that Mr. Labuschagne has now conveyed accords with what... do you accept that the Public Protector's report is capable of the interpretation that her remedial action, insofar as disciplinary action is concerned, is one in which the charges can be investigated on their merits?
On our reading of the affidavits and her report, and against the background of the findings in the Nkandla judgment and also of the Supreme Court of Appeal, it had appeared to us, and we think persuasively, that we could not challenge in a disciplinary inquiry, challenge the merits. What I call the merits.
Well, let's leave aside what the Public Protector has said in her affidavit subsequently, because ultimately this is a matter of the interpretation of her report.
Correct.
Do you adopt the stance that as matters stand, in the light of the Nkandla judgment, the disciplinary inquiry itself, and not merely the board, has to accept the factual findings? In other words, until your review is heard and potentially granted, that is the state of play.
That's exactly what we describe in our heads of argument as the dilemma that we had. This is the dilemma which the SABC had. On the one hand, the labour relations rights, the labour law rights of Mr. Motsoeneng. On the other hand, the binding quality of her findings. There was this opposition. We of course submit that the fundamental right under Section 23 cannot be defeated by the Public Protector. That's clear. But certainly, if she issues or makes findings which are written in concrete, then that poses a very difficult problem for us as the SABC, and that's the way it's been interpreted.
Well, the question always is who is bound by them. The remedial action is directed at, in this instance, the board. We know Mr. Motsoeneng, although he's interviewed in the process by the Public Protector, he doesn't there get to cross-examine people who criticise him. No. So why should one interpret her remedial action insofar as it directs a disciplinary inquiry to be held as binding Mr. Motsoeneng and the chairperson of the inquiry as to what the facts are? What must happen is that there must be a bona fide implementation of the remedial action. So the charges must be put and the case must be properly presented.
Put differently, is the SABC board, and to an extent the minister, is bound by her findings. They can't go and have another inquiry, but the disciplinary committee stand on its own legs in order to deal with the issues.
Well, that is the significant change which we now perceive. That's a significant change which we now perceive. And that's not what was reflected on the papers. And
well, it is still the position of the DA, so bear in mind that the applicant here is the DA, not the Public Protector.
Yes.
So the DA's position is that it's sanctions only.
Correct.
Yes.
Correct. That's the case we've come to meet here. And we say that can't be right.
Well, no. The case you've mainly come to meet seems to me now directed at the second application, not the disciplinary application. That, in the main case, it's still very much an issue whether, while the Public Protector's findings stand, the SABC itself can appoint Mr. Motsoeneng to a senior position. There we're not talking about a disciplinary inquiry. That
raises a different point, which I'd like to address you on. But I'm now dealing only with the...
I think we need to press on.
Okay, that's fine.
If I may refer you to the Nkandla judgment, and perhaps the wisdom of the Chief Justice should not be lost on any of us, because he does say, may I refer you to the judgment? I don't know if you have it in front of you.
I don't have it in front of me, but,
but you can read out the relevant
just identify the paragraphs.
Yes. I refrain from reading the text because I find that
tedious.
boring. But what he does say is that he does seem to create room for differences and a situation-based approach, if I may put it that way. In other words, he in this judgment, which sets out the position very clearly, I will refer you to page 609, paragraph 7 of the judgment. And then also at page 610, paragraph 73. And particularly these words: when remedial action is binding, compliance is not optional, whatever reservations the affected party may have about the fairness, appropriateness, or lawfulness. And then he goes on in the next paragraph to debate the question of whether the public protector's decisions amount to administrative acts. But on a careful reading, there might be ground, and I say this in the light of what I regard as a significant concession, there might be room in the Nkandla judgment for saying that the remedial action in this matter can include a revisiting of the findings of the public protector, which otherwise everybody had assumed were final and binding.
Just like a judicial commission can inquire into state capture.
You won't mind if I don't address you on that. So we came here because what the DA is trying to do is to prescribe to the SABC who they may employ. They are saying you can't employ this man because we don't like him, for one reason or another. Our answer to that was, you can't tell us who to employ, and it will set a very bad precedent. If a political party could come along and just dictate to an organ of state who they may employ. That's the first point. The second point, as we said, he has rights. He has labor law rights. And those rights must be respected. And thirdly, we say, in any event, a finding by this court along the lines sought by the Democratic Alliance would be premature in the light of the fact that we have conceded that a disciplinary inquiry must be held, a new one must be held. And in any event, it would be premature in the light of the review. And that's why we ask that that be stayed.
Disciplinary.
Suspended, yes.
The new inquiry.
Yes, because the basis on which the inquiry be held may be in fact set aside in the review. Now, I'm not briefed in the review, so I can't speak authoritatively of that, but nevertheless, that's how we understand it. Now, a point which has been raised here a number of times, and more particularly by Mr. Justice Rogers, is whether it is rational to appoint somebody against whom findings have been made unflattering and condemnatory findings have been made to a senior executive position. Now, we suggest respectfully that there's a fallacy in that approach. It's what the late Professor de Wet might have called a denkfout. The first point is, what is the job description of this position? And that job description does appear on the papers. It's at page 929. And if one looks at it, and I'm sure that Mr. Bester's client won't mind if I say it, it looks as if he's really a glorified public relations officer. He has external duties. He works with presumably other broadcasting stations. He also has organizational duties in regard to the various regional offices of the SABC. If one looks in particular at the main purpose of the position. The second point we want to make, so to conclude that point, sorry, he has no defining role as he had as Chief Operations Officer. He doesn't have that role. It's a subordinate role. The second point, of course, is that it's not a statutory office. The Chief Operations Officer is a statutory office. It's dealt with in the Broadcasting Act. But being a group executive is not a statutory office. The third point we want to make is that there was no appointment to this position. And in that regard, I would ask you to refer particularly to Mr. Aguma's affidavit at page 1095.
I have a grievance for.
No, sorry, I've given you the wrong reference. Just one moment. I've been misled by my juniors, and sometimes I'm. It's paragraph 11, it's 1067 in fact, sorry. Let's start at 11.20. The judgment of Davis J. did not, however, have the effect that Mr. Motsoeneng was no longer an employee of SABC. Now, Mr. Bester in his heads of argument has quite clearly addressed the difference between being a director and being an employee, and I don't need to repeat that. He was first appointed as an employee in 1995, was an employee in the position of Group Executive Stakeholder Relations at the time he was appointed as COO. He therefore, the SABC was advised, remained an employee notwithstanding the ratification of his appointment as COO. Now, just in this context, Mr. Justice Rogers raised a point concerning whether his term of appointment would run after 5 years. He raised in, I think it was 2011, would have expired already. I think those were the point. I would ask you to refer to section 186 of the Labour Relations Act, which defines dismissal. Dismissal means that an employee employed in terms of a fixed-term contract of employment reasonably expected the employer to renew a fixed-term contract of employment on the same or similar terms, but the employer offered to renew it on less favourable terms or did not renew it. So,
sorry, just read the phrase again.
I'm reading from from section 186, 1B, small Roman 1 of the Labour Relations Act.
Yes, would you just read it again?
Yes. To renew a fixed-term contract of employment on the same or similar terms, but the employer offered to renew it on less favourable terms or did not renew it. Or, and it goes on, to retain the employee in employment on an indefinite basis, but otherwise in the same.
It seems peculiar that a person can have a fixed-term contract which says you have no expectation of renewal, and then to say, well, a failure to renew it is a dismissal. But the answer may be it's a dismissal, but not an unfair one.
No, my lord, that's a dismissal. That's a dismissal. So, and a dismissal is qualified in terms of section 186 and 100.
Mr. Du Toit, on that basis,
Yes.
can you go to page 1096 of the record? 1096.
1096.
That was a letter to Mr. Motsoeneng from the board,
Yes.
where the SABC executive directors have decided to comply with the Supreme Court of Appeal judgment. And the effect thereof is that Mr. Motsoeneng will return to his former position as Group Executive, Stakeholder Relations and Provinces, now named Corporate Affairs, with immediate effect at the Scale Code 115. So it appears what has happened there is the group or the SABC executive directors have decided he will just have to revert to his old position.
Well, I was reading from paragraph at 1067, the paragraph 1121,
Yes.
where Mr. Aguma explains it. I was further advised that the effect of the judgment was to restore the status quo ante regarding Mr. Motsoeneng's employment that prevailed at the time that he was appointed in the office of COO. He was thus, as a matter of fact, an employee in the position of Group Executive. I informed him accordingly. I attach a copy of the letter. So, Mr. Aguma's approach was to say, right, Mr. Justice Davis has ruled that there's no question you can be COO, but now you fall back to what you were.
And were there then two people in that position?
No, because the Group Chief Executive Officer can allocate portfolios as he wishes.
Yes, but without deciding that Mr. Guana was going to move to a different position, if by operation of law Mr. Motsoeneng became the Corporate Affairs GE, then there were two people unless some other decision was taken.
Well, the decision was taken in cooperation with Mr. Guana that she would occupy a different group executive position.
She couldn't be compelled to do that.
No, I don't suggest she could compel, but the chief executive officer can allocate portfolios to group executives. That's what his job is. So,
and
the real point is he fell back to his position as an executive, a group executive. Whether he did A or B or C is really irrelevant.
But without an entitlement, unless a decision was made to allocate him a portfolio, he fell back as a person entitled to employment benefits, but without at that stage the allocation of responsibilities. Well, I put that to you for comment.
Yes.
Because it seems to me that at very least some decision must have been made that of the people at the SABC on our payroll, Mr. Motsoeneng will be the person to have this portfolio. And of course they had to conclude they did conclude a 5-year contract. And on top of that, not on the terms of a corporate affairs executive, but on the terms that he had had as the acting COO.
Yes, that's also dealt with in the Labour Relations Act. You can't reduce his benefits because that amounts to a dismissal.
Well, if the benefits arise from a position to which the appointment to which has been set aside, I'm not sure that's correct. But anyway, that's perhaps less significant.
Yes. Mr. Guma explains that the 5-year term is what every group executive has. But it doesn't mean to say that you cease to be an employee after the 5 years. I've tried to indicate that by reference to Section 186 of the Labour Relations Act.
The important point is, does this line of argument, the no appointment line of argument, have traction if a decision was required in order to determine that the portfolio that Mr. Motsoeneng would carry out would be that of corporate affairs?
Yes, it has traction in this sense also. And that's where we suggest that the approach or the question raised as to rationality is an irrelevance. And it's this, that his allocation to that job was not an administrative act. It was not an administrative act, and therefore rationality does not arise. And in that regard, I would ask you to look at a recent judgment of the Supreme Court of Appeal called State Information Technology Agency, SABC Ltd, versus Gijima Holdings Pty Limited. And it's...
What's the reference?
It's 2016 ZASCA 143, 30 September 2016. Now, in this regard, we know that the DA has, in their somewhat self-righteous way, claimed that they bring this application under the rubric of legality. Now, what the Supreme Court of Appeal says in this judgment is that legality is, yes, it is a part of the rule of law, but you have to proceed in terms of PAJA, in terms of the Promotion of Administrative Justice Act. That's the first port of call.
Is that correct? Is that what the SCA say?
Whether it's correct or not, that's what the SCA says.
So if it's administrative action, you must use PAJA.
Well, they say, can I read it to you? It's at paragraph 34. But the burgeoning principle of legality is arguably a greater threat to PAJA than recourse to the common law because it regulates the exercise of all public power. This includes, in addition to administrative decisions covered by Section 33 in PAJA, power exercised by the legislature and the executive. Then they quote an English judge, which we needn't look at. And in paragraph 35, because of the ubiquitous reach of the principle of legality and the fact that the administrative actions also fall within its remit, it is unsurprising that litigants and the courts have sometimes deliberately sidestepped PAJA. The reason is obvious. It is at times difficult to work out whether the unlawful action complained of qualifies as administrative action. Many of the elements of the definition remain unsettled. One only has to look at the difficulty courts have had in establishing whether the action in question has satisfied the element of having a direct external legal effect to demonstrate the nature of the problem. But it's not a problem that can legitimately be avoided. For if a litigant or a court could simply avoid having to conduct the sometimes testing analytical inquiry into whether the action complained of amounts to administrative action, PAJA, in Professor Hoekster's words, would soon become redundant. Put differently, the consequence of this would be that the principle of legality, unencumbered by PAJA's definitional and procedural complexities, would become the preferred choice of litigants and the courts, which is happening increasingly, and PAJA would fall into desuetude. This would be a perverse development of the law, one that the framers of the Constitution could not have contemplated when they drafted Section 33(3) of the Constitution.
I'm sure Mr. Katz is going to refer us in reply to a case, but I can't put my finger on it, where I think the Constitutional Court said that one shouldn't decide whether something is administrative action if one doesn't have to. In which case there will be either Homer or Virgil nodded.
Well,
But
I can only rely on what is binding on this court.
But the circumstances in which that will matter, the distinction will matter, is if a particular time limit would apply on Padger but might not apply to legality. Is that an issue here?
180 days, for instance, yes. But more important in this case was this appointment, call it an appointment, was his falling back into his job or his appointment, was that an administrative act?
Well, even if it wasn't, would you say there's one might say, because the legality principle applies what, to the exercise of public power?
Yes.
So the question might still be, was this appointment an exercise of public power?
But then you can't avoid, that's what the Supreme Court of Appeal says, you can't avoid having to determine whether that was an administrative act. Did it have Außenwirkung, as the Germans say? It didn't. This is an internal matter.
Is your submission that it isn't administrative action? That the appointment was not administrative action?
Absolutely.
Well, then we no longer have to be concerned with that. The question is it an exercise of a public power to which the legality principle can apply?
No, it isn't. It's an internal matter. It's an internal matter. It's an employer allocating a job to an employee.
And the same would apply if, without appointing him as COO, he had in fact been allocated a series of responsibilities which accorded with that of a COO.
Well, that's not the case.
No, I'm just saying, you're saying once the...
No, what you're suggesting, my lord, is vrouwslegers. It's not a question here of vrouwslegers. He's appointed to a different job. He doesn't have the power of a COO.
But so your argument would apply to any appointment other than, I think, the 3 executive appointments which are reserved to the minister by the legislation?
Absolutely. On what basis can a political party come dictate who's going to be appointed in the SABC to some job? Merely because it's an organ of state. Does it mean that a political party can start prescribing to departments of the administration who they may employ? But your lordship is avoiding what the Supreme Court of Appeal says you cannot avoid. You've got to define first whether it is an administrative act with external operation.
No, I'm not with respect to avoiding it. I was trying to suggest to you that if your argument is right, it doesn't matter, because on your argument it is neither administrative action nor the exercise of a public power. So there are limits to the legality principle as much as there are to administrative action.
Yes, but as we understand the Gijima judgment, it is that the court cannot avoid dealing with the matter in terms of the Promotion of Administrative Justice Act. Just to complete this at page 1067, what Mr. Aguma says at paragraph 11.22, my letter was merely a confirmation of Mr. Motsoeneng's falling back to his previous employment status and not any form of new appointment. I point out also that group executive posts are held for 5 years.
So is assuming that decision to engage him in the new position is regarded as flying in the face of the public protector's findings for as long as they stand, you say a court's powerless to deal with it?
Yes, I think the element of deference also should arise here. The element of deference which a court should have in regard to matters which fall under executive powers. This court cannot, at the instance of a political party, tell the SABC who they can employ. It's not a statutory post. He's not employed in a statutory capacity at all.
So your answer is that the court is powerless to deal with it?
Yes. What is perhaps important is that he's holding that position is really a business decision taken by the Chief Executive Officer, the Group Chief Executive Officer, Mr. Aguma. It's allocated him a job, he's an employee, he hasn't been dismissed, and that's not the effect of Mr. Justice Davis's judgment, sorry. He hasn't been dismissed as an employee, and in fact, this court cannot dismiss him as an employee.
If there were a quorate board, would it, in the face of the public protector's findings for as long as they stand, would it be permissible for the board to stand by and allow its chief executive officer to allocate this portfolio to a person against whom these findings have been made, assuming for the moment that the job description renders it inappropriate for him to be so appointed? Could the board stand by and allow that? Because the board is bound by the public protector's findings. We have a situation where there isn't a board that can bring Mr. Aguma to book if this is a patently irrational decision. But it shouldn't be allowed to be the case.
Lord, that appears to be the same point as your Lordship was previously making about whether it was a rational decision.
Yes, no, that goes back earlier. I'm trying to deal with your, explore your point that, however, assuming it is irrational, there's nothing a court can do about it. And I'm suggesting that if the board is bound by the public protector's findings, then it cannot stand by and allow one of its executives to do something which flies in the face of it. And the only reason why we can't seek why relief can't be sought against the board now is because it doesn't exist.
The board has the primary responsibility for running the corporation. That's clear. And it has a discretion in this context. It's governed by legislation and the way in which it must do it. Yes. But it does not mean to say that the Chief Executive Officer, who is entitled to employ people, is necessarily bound by the adverse findings in relation to that appointment. It's not a statutory appointment, it's a business decision which Mr. Aguma makes. And Mr. Aguma in his affidavit says a number of things about Mr. Motsoeneng. He says he's a colorful big character, but he has value. He's an asset to the corporation. His negotiating skills are, Mr. Aguma says, are particularly strong. He saved the corporation money in relation to a particular contract, a large amount of money. He has taken the initiative in relation to 2 programs, neither of which I have actually seen, but nevertheless, he's taken the initiative in regard to an alcohol program, I think it was, and the other one was, I forget now, but he's taken that initiative. He's also initiated programs, or he wishes to start channels dealing with, or not dealing with, but in languages, in other languages of South Africa. In other words, other official languages. So he's regarded as an asset Now, that corporate decision, that business decision by Mr. Aguma, how can that be said where Mr. Motsoeneng does not occupy a statutory position? On what basis can this court interfere?
Well, to put the more extreme case, say the public protectors, as a result of her findings, said that the SABC shall not employ Mr. Motsoeneng in any position whatsoever. And
well, she has said it, yes.
Yes, and I'm saying in her report, she specifically said that as part of her remedial action. If the SABC, represented by its chief executive officer, were to employ him to a position which isn't one of those reserved to the minister, it's a staffing decision falling within the remit of the CEO, make such an appointment, one could come to court and say the SABC, in this instance represented by its CEO, has done something contrary to the public protector's report. One wouldn't really have to say it's administrative action, it's exercise of public power. It would suffice to say it is contrary to in conflict with something which was binding on the SABC, represented by whoever had the authority to represent it in the decision in question. So here, we have not such a clear case, but all the same, if the SABC is bound to honour the public protector's findings, does it matter who represents it for a particular decision? That it's the board or the CEO or, for that matter, a lesser person? If the SABC, ultimately, if you ask Mr. Motsoeneng who his contract was with, it's not with Mr. Aguma, it's with the SABC.
Yes, of course, my Lord. But your Lordship is postulating a hypothetical case, and that's not what we're dealing with here. We're dealing here with what her recommendation was. Her binding recommendation, her remedial action, was a disciplinary inquiry. Now, if the findings of the disciplinary inquiry confirm that Mr. Motsoeneng is unsuitable for any position, as in fact the Democratic Alliance wants it, well then that's a decision which the SABC must then take as to what they do. And that would flow from Mr. Motsoeneng's labour relations, or labour law rights. In other words, would he be demoted? Would he be suspended for a period? Would he be dismissed? Dismissal is only the final remedy. But that's the remedy which the Democratic, the applicant in this case, wants already to anticipate. He must be dismissed now.
But Mr. Du Toit, if one unpacks your argument, it appears what you're saying is that we've got the public protector's finding, that's for the SABC to adhere to, but what happens internally, it's for the SABC to run its own internal affairs, if I understand it correctly. But what we've got here is the findings stand. I mean, Mr. Motsoeneng's employment contract is not with the internal department, it is with the SABC.
Yes, but surely the SABC can run its affairs as it thinks best.
Well, but we've got findings here of the public protector that's extremely adverse against Mr. Motsoeneng.
Yes.
And now what you're saying, if I understand it correctly, is that despite all of that, what the SABC do internally has got nothing to do with anyone else.
The CEO, you say, after a disciplinary process, assuming a disciplinary process finds that he's guilty on all charges,
Yeah.
and recommends his dismissal, and the CEO looks at it and says, okay, well, I think a first warning is appropriate. It's an internal decision, nothing to be done about it.
Well, I think the disciplinary inquiry, or the body that administers it makes a finding, not the CEO.
It may be that the disciplinary chair himself makes
they would decide
sanction.
on what the sanction is. That's how I understand it happens, and that's what the disciplinary code also says. But once again, my Lord, Mr. Justice Lefranzi, once again, you are anticipating the result of the disciplinary inquiry. You're saying that because of these findings, which we now know can be upset, according to the public protector, via a disciplinary inquiry,
Well,
therefore, in the meantime, he must be dismissed, and he's not allowed to hold any position. And that interferes in the right of the SABC to run its affairs. It is, after all, a company. The fact that its shareholders, the state, doesn't make it less an independent entity.
Well, the public protector's report was precisely concerned with how the SABC did run its affairs.
Yes, indeed. But that is so, but that's not the question that we're dealing with here. We're dealing with whether he can hold a job on a lower level, which is not a statutory job, and whether this court can interfere with that. On what basis? It has been mentioned in this court that some of the other cases that have been mentioned is, for instance, I think it was called the Hlaudi judgment. Of course, for that job there are jurisdictional requirements. There are no jurisdictional requirements for the appointment as a group executive. And even in the judgment of Mr. Justice Davis, he conceded in paragraph 52, if one looks at his judgment, that if the disciplinary inquiry in fact finds that all these charges are not valid, then he can conceivably be chief operations officer. That's what Mr. Justice Davis found. Your Lordships have contemplated the modification, if I put it that way, of the relief which the Democratic Alliance sought. There's no amendment to that, the relief it seeks.
So modification, what are you referring to there?
The modification in some way, it's been debated here as to whether the suspension should be made on full pay, or whether he should be, that's not what the Democratic Alliance asks for. They say you can't hold any position at all. So we come to meet that case, not one which is modified here. They've not asked for alternative relief.
Well, the greater includes, if one feels, if the court considers that relief should be granted but not in its most extreme form, then without amendments the court can fashion something falling short of it. What we can't do is grant greater relief that wasn't sought.
Yes, of course. I would like to refer you also to a judgment by Mr. Justice Malambo, just dealing with procedural fairness. It's in the Labour Appeal Court. It is, it's called, I can't pronounce it, SCEPPWAWU. Sepwawu.
Yes, that was one of the trade unions that didn't adopt a convenient acronym.
Yes. An inconvenient acronym. Against Metrofile, perhaps that's easier. And where he referred in particular at paragraph...
Sorry, the reference, the citation?
Oh, sorry, yes. It's case JA 37/01.
I'm not sure that's going to help us very much. Is it on SAFLI or in a labour law report? You don't know at this
I rely on my
stage.
juniors to provide the judgments to me in some form or
All right,
other.
what year was it in?
It's,
Is it on SAFLI?
It probably would be, but
it's fairly recent. He was, sorry, I can't even see that. It's a judgment of Mr. Justice Mlambo, Mr. Justice Zondo, and Mr. Justice Goldstein, all in the appeal court. Got something more. Oh, yes, thank you, my Lord. I've now been, it's 2003 ZALAC, ZALAC 22, 9 December 2003. It's just to...
sorry, what's the number after the LAC? 2003 Labour Appeal Court?
ZALAC 22.
22.
Yes. I apologize that I don't have a clearer reference now. It's just that in paragraph 55, he states that the right to be afforded a fair hearing before one's dismissal is indeed an integral part of our law. The right is explicitly recognized by the Act and has been restated on numerous occasions in this court. So there can be no doubt that the attaching immutable consequences to the remedial action conflicts with fair labor practice. Now, one of the things that has been attacked here was the Eerdling hearing. Can I call it the Eerdling hearing? And in fact, the Democratic Alliance has gone so far as to accuse my colleague in Bloemfontein of being part of a conspiracy, an unfair accusation, which I think he does not deserve. If one reads his ruling, it is quite clear that the initiator sought a postponement in order to call further evidence to substantiate the charges. But Mr. Eerdling, in his wisdom, regarded that as being an indulgence which he was not prepared to grant. So it's not the fault of the initiator for not seeking to adduce more evidence to the hearing. It is the decision of Mr. Eerdling, and to call him part of a conspiracy is really far-fetched. And certainly, it doesn't reflect on the SABC, because that's Mr. Eerdling's decision, not the SABC's.
What may reflect on the SABC is that once Mr. Makari decided to dismiss or to say that the disciplinary charge had become moot, Mr. Polani was instructed, and one infers from whoever within the SABC gave instructions, that he had to deal with the case on the same day that he was notified to take it over. So
Yes.
it's hardly surprising that he was not in a position to present the case properly.
Yeah, I think it's quite excusable that he couldn't present the case as fully as he would have liked to.
Yes, personally, I didn't see that Mr. Polani was necessarily to be blamed. All for that, I don't know about. I don't want to cast aspersions.
There's nothing on the record to tell us why they were, when Mr. Mukari withdrew, why they were given short notice. Perhaps the pressure of the 60 days caused that. One doesn't know. It's possible that the SAB said, well, Mukari has pulled out, what do we do now? let's find a different advocate and appoint him, and we have to do it quickly. It's unfortunate, but it's not explained on the papers. But to accuse Mr. Eerdling of being part of a conspiracy is far-fetched. Now, I want to deal with a few points and a few authorities which, and if I can just refer briefly to our heads of argument, which I've not done so far. I want to, in paragraph 4 of our heads of argument, which were prepared by the three of us. Unfortunately, Mr. Curry could not make it out for personal reasons. Paragraph 4. The SABC has conceded there are grounds for review and setting aside of disciplinary proceedings. That's clear. Paragraph 5. We do not contest that the SABC board is currently unable to find a former quorum. Well, when this was written, there were still a few people there, but now, in fact, there's nobody there except Professor Maguire. And that fact impacts on the validity of the appointment by the Minister of Ms. Dugwana as acting COO. That is so because there's no board to confirm, correct board to confirm her appointment. So that we concede also. We say that the Democratic Alliance's case turns on a misreading of the judgment of Mr. Justice Davis, a refusal to accept Mr. Motsoeneng as an employee of the SABC, and a disregard for his constitutional and statutory rights. So I've addressed that already. I've pointed out that these rights arise out of Section 23 of the Constitution, 185, 186, and also 188, I would draw your attention to, which is a dismissal which is not in accordance with fair procedure. It's 188(1)(b). Now, we made the submission in paragraph 7 that it's a fundamental right, and then we say that his removal preempts the result of the very disciplinary process. And we ask there, we would like to refer to the relief we ask in relation to, also to Ms. Dugwana, that even though this court might confirm that her appointment could not be made, her actions up to date not be set aside, because that would upset the arrangements that she might have made in the past. And we also ask that any order be suspended until the end of December in order to allow for the possible appointment of somebody. of a board
But
and of...
if it's been made unlawful, can we, as a court, suspend an order of that nature?
Well, a suspension can be, a court has the power to suspend an order. As Mr. Justice Rogers in, I think it's called the Kelly Group case, he made such an order. You can suspend
The end of
effect of the judgment.
in December 2016 may be optimistic for believing there will be a chorus board. But
Well, the SABC cannot appoint its own board. It has to be done by a parliamentary committee. Whether they're going to assemble before the holidays, I don't know, but one can only hope so. And certainly we do know that the parliamentary committee is being active, but that's not something which is our hands. But what is clear from Mr. Aguma's affidavit is that the SABC needs a COO, needs a chief operations officer. It's a necessary post. He makes it absolutely clear. Perhaps it's been suggested here, I think, in argument, that there are no facts to support that. That's simply not correct.
what position has she been appointed to without adequate authority?
She was appointed as acting COO.
Is it that appointment that is attacked?
Yes.
Yes.
It's that appointment that's been...
And is she I assume she wouldn't have been a director before that appointment. Has she? If you become an acting COO, does that carry with it the directorship
Yes.
that the Broadcasting Act?
Yes, my lord, it does. Yeah, that's what the Broadcasting Act says. The three officers, the chief executive officer, the chief financial officer, and the chief
You
operations
know, I'm not sure if it
officer
has the provision that one sometimes finds that
ex officio.
that a particular position will include a person acting in that position. The Broadcasting Act doesn't actually say that, but it may be the case.
Well, I understand that to be the case for the AA because they pointed out that Motsoeneng, who was acting in a position, was mentioned in a minute. By the way, I want to correct that decision where his name was referred to in the head note of a minute. That's acknowledged on the papers to have been in error. It's not something where he participated in the decision. I'll give you the reference in a moment. Mr. Aguma makes it clear in his affidavit that the position of Chief Operations Officer is a vital one for the functioning of the SABC, and that it is a necessary post.
Isn't it staggering that the SABC seems not to have had a permanent COO since 2008?
Yes. But that doesn't lie only in the hands of the SABC.
No, just does seem to be a remarkable state of affairs.
I think the president has been around since 2007, if I remember correctly. Yes. Can I refer you to paragraph 6.8 and onwards as to the importance of the position of Chief Operations Officer? We went so far in the affidavit, or Mr. Aguma goes so far as to ask this court, please intervene and appoint her. We haven't followed it up in our heads of argument because we're not sure if this court can, quite frankly. We don't believe that Paja would allow this court to go that far.
I think you're right.
But it does point out the despair of the SABC in relation to the necessity of having a chief operations officer.
What may be explored is whether, when a company doesn't have a quorum, or in this case the required number of directors, whether the shareholder can govern the affairs of the company. Whether that's desirable is a different matter, but I think that used to be the position with companies, didn't it? That if for any reason the board was unable to act, the residual power of management vested in the shareholder.
Yes, there is some authority to that effect.
Who is the shareholder, the government or the...
The shareholder, the government, yes.
Represented by the minister.
As represented by the minister, yes.
Yes, I'm not sure the applicant would like this suggestion, but...
Well, then they must go back to the ballot box and see what... Yes, the error we point out, I said I would give you the reference, it's paragraph 11.18, where we say his name was included in error. I was just dealing with some of the points arising from our heads of argument. We point out the dilemma that we had in paragraph 18. The dilemma being the contradiction between the binding quality of the findings of the public protector and the labour law rights of Mr. Motsoeneng. We'd like to refer also specifically to paragraph 61 of our heads. In relation to the review application, we abide the granting of prayers 4 and 5. We abide the granting of prayer 1 to the extent that it's rephrased to read as follows: the failure by the first respondent to comply with the remedial action ordered by the public protector in a report of 17 February is inconsistent with section 83B of the Constitution, as read with section 181.3 and 182.1c of the Constitution and the irrelevant. We suggest that declaration should be rephrased in that manner. But we do ask in paragraph 61.3 of our heads of argument that the disciplinary proceedings be stayed until the finalization of the review instituted in case number 39679 in Gauteng. We therefore propose prayers 6 and 7. We, as far as prayers 8 and 9 is concerned, we would ask that they be rephrased not to limit the powers of the chairman of the disciplinary inquiry to regulate attendance as he deems fit. We would refer you to a case called Media 24 and 2 other publishing companies against the Department of Public Works. It's a judgment by Mr. Justice Kuhn in Natal, in KwaZulu-Natal High Court, Pietermaritzburg. It's... Have you got the proper reference here? It's...
What's the citation?
He's got it off his telephone.
Oh.
Yes. Thank you. It apparently is 2016 ZAKZPHC 52, and it's also reported in 3 All South African at page 870. 3 All South African 2016. 2016 3 All South African at page 870. What he did in this case was to issue a judgment regulating the access of the press to a particular hearing. He says it is clear that where the media access is allowed, the chairperson of each disciplinary inquiry always retains an overall discretion to recall or vary the terms of the earlier rulings. And we would recommend that this type of order be granted in order not to limit the powers of the chairman unduly. As far as costs are concerned, we have suggested that we do not seek costs against the Democratic Alliance, and we do not oppose the granting of the relief to the extent indicated, and in those circumstances a just order with each party to pay their own costs. Now, as to the main application, the SABC advised the granting of prayer 5. SABC abides the granting of prayers 3.1 and 3.2, but seeks an order limiting the retrospective effect of any order of invalidity and suspending it until the expiry of Ms. Dugwana's acting term of office. We ask that the remainder of the relief sought be dismissed.
Just in terms of your paragraph 6.2.2, you
yes.
say until the expiry of Ms. Dongwana's acting term of office.
I think it was 27 December.
Is it December
2016?
2016.
And once again, the SABC doesn't seek costs, and if the court is with us, we think that we've achieved substantial success, and that each party should pay its own costs. Oh yes, there was a point raised. Sorry, this is another point. We respectfully submit that Mr. Justice Rogers is correct in dealing with the question of preemption. That was there a waiver, and that's really the test. And we submit that there was no waiver at all of any right to review. Oh yes, I'm reminded that our authority has been put in issue at one stage. I don't know if they want to pursue that, but in relation to the review application 3104, that authority arises out of the decision taken when the board was called, and that was in, I think, in February or March, I can't remember when. So that point doesn't arise there, and Mr. Aguma was perfectly entitled to say he's authorized by the board there. In relation to this matter, I'm not sure it's been raised in relation to this matter, but for ex abundante cautela, I state that we are authorized by the executive committee to represent the SABC. my attorney, who's unfortunately ill today, is authorized to do so, and therefore we are authorized to do so. We have an affidavit which we can hand up, where the deponent says that when she gave, we attach a copy of the resolution which refers to the board. She says that was an error on her part. It should have referred to the Group Executive Committee. The resolution is exactly the same as the one which is attached to our papers. Yes, just hand them a copy. Thank you.
Thank you.
Last but not least, the rather vindictive approach of the Democratic Alliance in relation to costs.
What did we see? Maybe I got the attachment. You got the attachment. Yeah.
Justice Katanzi has the original in his hands, we think.
Is this the original here? Yeah. Yes, thank you.
It's just a question of the rather vindictive approach of the Democratic Alliance to the question of a personal order of costs against officers of the SABC. If your lordships are against us, we suggest that those officers should not be punished in that way. Mr. Aguma, certainly, who represents the SABC, is only doing what he thinks he should do. He personally has not done anything which can be labeled as malice. And malice is really the basis on which a public official can be burdened with the order of costs. There's nothing in his affidavit that suggests that at all, nor does the attitude of the SABC. And the concessions which have been made by the SABC indicate anything other than a reasonable attitude towards what is a difficult situation. It was difficult because it only became clear after the Nkandla judgment exactly what the extent and effect was of the requirements of the public protector. Indeed, they refer to in the judgment of the Supreme Court of Appeal, but these were elaborated on and clarified by the Nkandla judgment. And that certainly has influenced the attitude of the SABC in this matter, because they have realized that the disciplinary hearing that was conducted previously did not appear to comply with the requirements of the public protector. There was nothing in the actions of Mr. Aguma which can be described as malice, which would bring with it an order for personal liability at all.
Anything else, Mr. Tutoy?
I'm just looking for, I was looking around to see if my attorney who's indisposed has been managed to come to court, but he has not been here. Thank you, Lord.
Thank you. Mr. Maneki, are you ready to proceed? And can we push on until about 1 o'clock and then we can adjourn for the lunch hour?
Yes. Our submissions, as we have seen from the answering our claims on behalf of the Minister and the heads of argument filed, are limited to the brief that is directed against the Minister. And in that context, I will deal with 4 matters, I propose to deal with 4 matters. The first is to respond to certain submissions that were made by the public protector that affect the minister. And the second is to deal with the prayer 3 under the review of the disciplinary action. And the third to deal with prayer 3.2 in the main case, the main application. And then the last to deal with the issue of cost orders on a special basis. In relation to the submissions made on behalf of the public protector and the minister, there was at the outset a submission made that the crux of the submissions for the public protector is that there has been a failure both by the minister and the SABC to comply with the remedial action of the public protector, and specifically that they have breached Section 1813 and Section 182. Now, the first point we want to make is that the DA, which is the applicant, seeks no relief against the minister to the effect that the minister breached Section 1813 and 182 of the Constitution. And under the review of the disciplinary action, the relief in respect of Sections 181 and 182 of the Constitution are in paragraphs 1 and 2. And my lords will see that those paragraphs are directed at the first and second respondents, and the second paragraph on page 2 is directed at the first, second, and third respondents, whereas the minister is the fourth respondent. And in respect of the main case, that relief is to be found at page 4 of the notice of motion. Paragraph 4, and that page 3 of the notice of motion is paragraph 4, and that too is directed at the SABC, the acting CEO, and the board. And the allegation, the prayer sought is that they violated their constitutional obligations in terms of Section 1813 of the Constitution. That's the first point. And in that regard, the public protector is not a co-applicant, has not sought any relief in respect of any allegations that has been made, allegations made in the public protector's answering affidavits about the minister breaching Section 181 and 182. And secondly, it's relevant that the only case that is brought here in respect of remedial action relates to the disciplinary action and the appointment of Mr. Motsoeneng, and not any other remedial action that might have bound the minister. So to that extent, that is the only case that the minister had to meet, and not some allegations hidden somewhere in the public protector's answering affidavit, because the minister had no right to reply to another respondent's answering affidavit. So there isn't a case made out by the DA of a broader failure by the minister to comply with the remedial action of the public protector. And had that been the case, there might have been an explanation on the part of the minister as to what she did or didn't do to comply with the public protector's remedial action. So we make this submission simply to say to the court, there is no basis on which the court could make a finding against the minister of a failure to comply with the public protector's remedial action. And perhaps it's significant historically here that we are concerned with the period after the judgment of the SCA, not prior to that. Because it's only after the judgment of the SCA, it's only the conduct of the SABC and the minister after the judgment of the SCA that the DA brought to the court for appropriate relief. The second issue that the public protector made submissions about regarding the minister is that it was submitted that both the minister and the SABC now concede that the review of the disciplinary action must be granted. And that is considered on the basis of the interpretation that the public protector attached to her findings in her answering affidavit. Now, that is a concession that the SABC has made and has been repeated, and there was debate with the bench about what appears to be a change in stance on the part of the public protector. But the minister has made no such concession. What the minister has said is that in respect of the review of the disciplinary action, the only relief that affects her is paragraph 3 of the notice of motion. And she accepts that she made the appointment of Mr. Mukari SC as the chairperson and Mr. July as the initiator, but she made the submission that that appointment, whatever finding the court makes as to whether it was lawful or not lawful, has no impact on the outcome of the disciplinary inquiry because their involvement was terminated at a point. Mr. Mukari, as we know, withdrew on the basis that the disciplinary inquiry before him had become moot, whereas Mr. July, I think it might not be said on the papers, but also left the office, as it were, as an initiator, and a subsequent initiator was appointed. So the minister says in her answering affidavit, the first one that was filed, at page 191, at paragraphs 25 and 26, I don't need to take the court there, makes the submission that her appointment of the initial chairperson and the initiator can form no basis for the review of the disciplinary action because it doesn't translate, as it were, into the final outcome. But I'll make submissions on why even that ground is not sustainable on the facts and on the law.
Although presumably the review of the disciplinary proceedings covers what is sought to be set aside, covers the entire period from 12 October to 12 December 2015. So I think among the things that we are asked to set aside are presumably the rulings that Mr. Mukari made. And one of the grounds for that would include perhaps the fact that he wasn't duly appointed.
Malo, that's an interesting proposition because if one construed it that way, that the review relief covers the setting aside of Mr. Mukari's decision, then it makes a mockery of what the DA argues before this court. What the DA argues is to adopt precisely what Mr. Mukari found, which was that once Mr. Motsoeneng was appointed to a statutory position, he abandoned his prior position, and once this court set aside the appointment as a COO, and that was confirmed by the SCA, he no longer has any position at the SABC. So they would never seek that.
Well, perhaps what is also relevant is that Mr. Mukari isn't cited as a respondent in the case. So it seems, come what may, everybody involved in this case thinks that the disciplinary proceedings should not have been aborted on the basis that Mr. Mukari did.
Yes, we accept it. But that's not a challenge. That's not a challenge brought. What they only seek is that his appointment be set aside. His appointment was an unlawful interference with the powers of the board and forms a ground of review of the disciplinary inquiry itself. It's only in that limited context that I make the submission that the minister says, even if that were true, it would have no effect on the outcome that is sought to be reviewed and set aside because he didn't carry through to the final outcome. But in any event, I'm going to submit that that's on the law and the fact there was no unlawful interference by the minister, and that prayer in paragraph 3 can't be granted anyway. And it is to that I attend. That prayer, my Lord, is as it is. It says, declaring that the fourth respondent acted unlawfully by improperly interfering in the appointment of the initiator. So it rests on two premises. The first, my Lord, is that the minister had no role to play in the initiation of the disciplinary proceedings against the COO at the time. That's the first proposition. If there was no lawful basis on which the minister could be involved in the initiation of the disciplinary proceedings, then they say it was an unlawful interference. Now, my Lord, the memorandum of incorporation gives the minister an explicit role to play in the initiation of disciplinary proceedings against the three top executives, the statutory office holders. And my Lord will find that at page 708 of the papers in this 708 in the main case, because that's where the MOI is, as opposed to in the review of the disciplinary inquiry. 708, paragraph 13.6.3, the MOI provides this: the board shall have all the rights and powers to institute any disciplinary proceedings against the GCEO, CFO, or COO, as the case may be, upon the approval of the minister, and also have the right and power to suspend the employment of the GCEO, CFO, or COO upon the approval of the minister, as the case may be. That might, if I flag that might be relevant to the issue raised earlier by the court about how to deal with the appointment of a chairperson, independent chairperson, going forward in the light of the incorrect board. So there is a role reserved for the minister. And my lord, the order that was granted by His Lordship Justice Skeepers.
Which is the clause in the MOI?
At page 708.
Yes.
Clause 13.6.3. So it gives the power on the board to initiate disciplinary proceedings, institute disciplinary proceedings against the CEO, CFO, and COO, but upon approval by the minister. And the same with suspension is upon approval by the minister. And that makes sense, my lord. That is the appointing authority. The minister has been the appointing authority of all of those executives.
But if she can approve the institution of disciplinary proceedings, does it mean she can appoint the chairperson and prosecutor?
Precisely, my lord.
Why?
All it means is, all it means is that there would be nothing unlawful in the board requesting the minister's involvement in the appointment of the chairperson and the initiator. It wouldn't, on the face of it, equate to an unlawful interference in the powers of the board, because there is a role lawfully preserved for the minister in the MOI. I'm not suggesting for one moment that the MOI expressly says is the power of the minister to appoint a chairperson and initiator. But what it doesn't do, what the MOI does make clear is that if the board, on its own choice, were to invite the minister to assist it in instituting the inquiry, for example, in appointing the chairperson and initiator, which is what the board did here, that would not be an unlawful act on the part of the minister, let alone on the part of the board. And recall, my lord, my learned friend for the DA read to your lordship the correspondence exchanged between the board and the minister, requesting the minister to assist in appointing the chairperson and the initiator. And my lord, that is attached to the minister's supplementary answering affidavit. I don't need to take your lordship there. What the board explained is that given the previous attitude it took in respect of the discipline of Mr. Motsoeneng, which was that there's no basis to discipline him, it then took the view that it would be better if the minister were to appoint the independent chairperson and the initiator. May have been a decision taken wrongly, but with respect, advisedly, correctly, because then it does away with any impression of potential charade or sham as has been submitted to this court. And there was nothing unlawful in that regard. But I dare say
if I understand your argument properly, in terms of the MOI, there's nothing on the face of it unlawful in terms of what the minister has done.
Precisely. But then there's even a rider to that, because the order is that it was an improper interference. It's not an improper interference when it's done on the invitation of the board. And the minister makes it very clear in her letter appointing the two persons that she awaits the concurrence of the board. That was her expectation. That the board may or may not have concurred doesn't, with respect, vitiate the propriety of what the minister did. She did it on the basis that they would apply their minds and they would then accept it. So the first premise, my lord, that it was unlawful is not borne out by the MOI, borne out by the facts. The second premise is that there was some kind of conspiracy or shame to shield Mr. Motsoeneng. And that is why the minister was requested to appoint a chairperson and initiator. And we've had very gratuitous submissions made against a colleague who's not even cited in these proceedings that he'd become rogue. Now, the suggestion that somebody became rogue is that they were previously pliable. There's nothing on the affidavits that suggests that. What the minister did is bona fide appointed Mr. Mukari and appointed Mr. July as both chairperson and initiator, and the conduct of Mr. Mukari is inconsistent with a sham, because in his view, in fact, this court terminated Mr. Motsoeneng's appointment. That can never be reconciled with somebody who was pliable from the outset. The second important point to make, my lord, in respect of this improper interference is that this court, in the order it granted, the order that Justice Schiepers granted, and that is in the bundle that my learned friend for the DA handed up yesterday, starting with the Section 16A submissions. You will find in the order, that order simply said that the board must commence disciplinary proceedings and then by way of serving on Mr. Motsoeneng a notice of charges and then regulating the time period. It didn't exclude any role that the minister might otherwise have under the MOI or under the legislation. And so what the minister did was not in contravention of the court order. And that is one of the pillars on which the argument rests. So we submit, my lord, that on both premises that the minister's appointment of the chairperson and initiator was an unlawful interference, that fails, and that there was some kind of a conspiracy, that too fails. And so the order that is sought in paragraph 3 of that notice of motion cannot with respect be granted. Now, if I may, whilst I'm there, just finish off with the disciplinary action review, is that as my learned friend for the SABC, Mr. Dutoy, submitted, there is a almost cavalier attitude that the DA approaches the court with, that these are bad people, they always are bad people, and the court must forget about what the real facts are and must condemn their conduct. And it's in that context that they seek a punitive course order, my lord, against the minister. And you find that at page 4 of this application dealing with the review remedy of the disciplinary action at paragraph 11, that it sought that the cost of the applicant, including the cost of 2 counsel, shall be paid jointly and severally and personally by any respondent opposing the relief sought in this application. The minister simply opposes paragraph 3 and has a very valid basis for opposing it. In fact, she seeks that that relief be dismissed with costs, rightly so. Then, my lord, I turn to prayer 3 of the main application. Now that is relates to the appointment of Mrs. Tugwa, and that is at page 3, paragraph 3.1 and 3.2. And whereas the minister initially opposed both 3.1 and 3.2, on reflection and on advice, has conceded in the heads of argument that paragraph 3.1 may be granted because we accept that where the board was not correct, the decision to appoint Ms. Tugwana upon the approval of the minister would have been invalid. Of course, my lord, we could have made the argument which His Lordship Justice Rogers raised, that isn't there residual power that a shareholder might exercise in instances of this kind? We didn't make the argument, and we're not going to take advantage of a point that was not explored properly in the papers, but I just flag that in the actual appointment, which your lordships will find at page 1075, if my pagination is correct, the letter of appointment.
1075.
1075. Is that not the correct one? So it might be round about that area, but not exact. One more?
What paragraph?
1083.
What paragraph?
Page 1083.
Yes,
In the main case.
Yes, which paragraph are you wanting?
Oh, yes. I'm just reading from it's the letter itself.
Oh, no, I don't have that. 183?
1083. I did the pagination myself, so I have no one to blame. My Lord, you'll see that. So what the board does there is, in the first paragraph, acknowledge that it's incorrect, and therefore resorts to the minister as ask the minister to be the appointing authority, on the basis that when a board does become correct, it may ratify the appointment. This is important because generally, my Lord, courts will not set aside invalid decisions which are capable of ratification. But so that's what the board says there, and then it asks for an appointment for 3 months in line with the memorandum of incorporation. And you'll see at the bottom of the page, foot of the page, my Lord, that the minister exercises that appointment in her capacity as a shareholder representative of the SABC. So that's the capacity in which she acted. And we would submit that, my Lord, is relevant to what kind of remedy, when we get to just and equitable remedy, this court can grant. Because aligned to other considerations on just and equitable remedy is the extent of the breach of the rule of law. If the extent of the breach of the rule of law is egregious, that factor would be put in the pot in determining what a just and equitable remedy would be. And here we submit that would be it's a narrow breach, because here she's exercising the power in her capacity as a representative of the shareholder, and does so purely in the interest of the SABC. My Lord, in circumstances where we've quoted in our heads of argument the actual provision which allows for the appointment of an acting COO, that you're required to appoint a suitable person. Now, our learned friends for the public protector submitted to the court that for senior appointments, you need integrity and honesty as the minimum requirements. We didn't understand that to mean that journalists don't have to have those qualities. We understood it to mean that that's the minimum for a senior executive position. Now, in this case here, there's nothing on the record to impugn the integrity and honesty of Mrs. Tuba, nor her competence. So when your lordships go to looking at whether a just and equitable remedy might involve a suspension of any declaration of invalidity, those loom large with respect, because it's those on the one hand, and it's the interest of the SABC to have an effective executive committee running it. Now, we are here with the DA telling us this body, the SABC, is being run into the ground, both because it has an ineffectual board, one man standing, and it has an ineffectual executive committee. But they say to your lordship, shouldn't entertain a suspension of a remedy which allows the board to have in its executive committee the full complement that the Act and the MOI requires. We submit that if the DA really comes to court in the public interest, it should be the first one to support a suspension remedy in circumstances where it has no questions about the integrity and honesty of Ms. Tubana and her competence. Now, if I may, in that light, address myself to the question that His Lordship Justice Lakranje raised with my learned friend, Mr. Dutoy, whether the court can grant a suspension remedy which in effect perpetuates an invalid act.
Can I just clarify? Do I understand that you're not pursuing the Section 6611
No, we're not. We say so in our heads, my Lord. It would be a dead end. His Lordship raised the question: Can the court suspend this declaration, which effectively means condoning an invalidity? Well, that question was addressed in the case of Bengwenyama Minerals. Bengwenyama Minerals versus Genora Resources. It's 2011, Volume 4, SA 113. Is a decision of the Constitutional Court involving a administrative action and whether the court could suspend what just and equitable remedy the court could grant. And the court grappled with that And it says in paragraph 84, I read just the one sentence, that the discretionary choice, the discretion is the same under PAJA and under 1672 of the Constitution. It's all about what is just and equitable. And the quoted paragraph 84 says the discretionary choice may not precede the finding of invalidity. The discipline of this approach will enable courts to consider whether relief which does not give full effect to the finding of invalidity, which is the question being asked, is justified in the particular circumstances of the case before it. And then it goes on in paragraph 85. The apparent anomaly that an unlawful act can produce legally effective consequences is not one that admits easy and consistently logical solutions. But then the law often is a pragmatic blend of logic and experience. The apparent rigor of declaring conduct in conflict with the Constitution and PAJA unlawful is ameliorated in both the Constitution and PAJA by providing for a just and equitable remedy in its wake. I do not think that it is wise to attempt to lay down inflexible rules in determining a just and equitable remedy following upon a declaration of unlawful administrative action.
So if I understand your argument properly, that under these circumstances, having regard to what we've got here with the SABC and its board, it's prudent that we suspend the...
Absolutely. I'll address myself as to how long one does, for how long that must be done. The second point I must address in that context also is our learned friends for the DA's submission that in the absence of evidence on record, the court is not in a position to exercise that discretion. First, we submit as a matter of law that discretion always follows upon a declaration of invalidity. So the court has to address itself to what a just and equitable remedy would be. And that's the cases are clear, and we've referred to some of them in our heads of argument. But secondly, now the question of evidence. We have referred in our heads to certain facts which we submit are relevant. The court will have regard to those. But secondly, my learned friend for the SABC, Mr. Steff, has pointed out to where in the affidavits of Mr. Aguma the importance of the position to the SABC is dealt with.
You said Mr. Steff, you mean Mr. Dutoy?
Mr. Dutoy. Did I say? Oh, yes. Mr. Dutoy, I beg your Lordship's pardon and his pardon. May I take first? The other point I need to respond to is, well, assuming that that evidence was not sufficient, is it correct that in the absence of sufficient evidence, the court can't exercise the discretion anyway? We submit that doesn't follow from the judgment of Dawood that our learned friends referred the court to yesterday. He read from paragraph 17 of that judgment. I think it was handed down if I'm not mistaken. It says 17, our Constitution recognizes the separation of powers, holds high the rule of law, and enjoins all organs of state to protect the Constitution. Within this scheme, this court is given the special and onerous responsibility finally to determine the constitutionality of legislation. Once it concludes that legislation is unconstitutional, it must declare it invalid, which follows even in this case. Such an order may be tempered by ancillary orders that are just and equitable. In the light of this constitutional scheme, this court can best carry out its task if careful and detailed evidence and argument are placed before it by those in government qualified to do so, particularly when legislation is under challenge. So it's best carried out in those circumstances, but that doesn't mean absent those circumstances it can't be carried out. And we submit this is a particularly apt case in which, even assuming there was no evidence.
But what Mr. Katz has argued is there's only argument but no evidence.
Well, but there is evidence here and then some argument. But let me put this to the court, my lord. This is a special, this case, and on this issue, is an exceptional case. It's different from Simelane, because in Simelane, when the court set aside the appointment of the NDPP then, the president was at large to appoint a new NDPP. But in this circumstance, if the appointment is set aside, the board, the SABC is not at large, or the minister is not at large to appoint a new acting CEO, because it's incorrect. We will be back here with a new appointment. So this is a kind of case that calls for the court, in effect, to come up with a creative remedy that will be just and equitable in the interest of the SABC and the public, because this is an organ of state. And it's in that context, my lord, where we asked we asked for a slightly more ambitious remedy than our learned friends for the SABC. We asked that the appointment be suspended pending the constitution of a Corred board, because it doesn't help to get the appointment suspended up to December. If the Corred board is not appointed, then we are in the same position. So and the memorandum of incorporation anticipates that there may be situations where the appointment may have to be extended, and that your Lordship will find at page 709 of the papers in the main case. At clause 13.7.4 says any person appointed to act in the stead of the GCO, CFO, or COO, in brackets as the case may be, shall only be appointed for a period not exceeding 3 months, subject to any extended period being approved by the minister. And in the event of the minister approving such extended period, that person shall be an ex officio director as contemplated in section 6641A2 of the Companies Act. So this is the submission we make is twofold. First, if your Lordships find that the minister has the competence under this clause that I've read to you to extend the appointment of Ms. Tugwana once the invalidity is suspended until the end of December or until the end of the initial period, then there is no need to be crafty about the form of remedy. But if your Lordships find that once the initial appointment was invalid, any extension that follows based on that would also be invalid by the minister, then the court might have to say something about what happens post-December. Can the minister simply extend this appointment? If the minister forms the view that Ms. Tugwana remains the appropriate, suitable in terms of the MOI, has integrity and honesty and can continue to discharge the function of COO, can she extend it further at the end of December? Our submission is the court must either express its view on whether an extension by the minister will be competent under page 709, paragraph clause 13.7.4 of the MOI. We submit that the MOI is capable of that interpretation, that as a shareholder, if she's still satisfied and the invalidity was suspended, she can extend it prior to it falling, lapsing. But if we're wrong on that, then we ask the court to grant the suspension of the declaration of invalidity until we have a Corred board appointed, which would obviate the need for an extension by the minister.
But sitting here and just listening to the debate so far and also listening to you, how did it happen that the main stakeholder allowed this situation to arise?
Well, yes, that's unfortunately is not something I can answer because it's not canvassed on the papers. It's something that I would need to get proper instructions and something that would have to be conveyed to the court on oath. Reading from the newspapers, we can form our views, but with respect, my Lord, I cannot give an answer that is fully responsive to the question raised. It is a problem that must be addressed and must be addressed sooner rather than later. But for present purposes, we just want the SABC to have a steward at the top and properly constituted of the 3 executives in order to run the ship until there is a board that's functional. And we submit that the court has the ability to do that, has the power to do that, and the facts would justify that because all the parties before you, all of them, both the DA, the public protector, and all of the respondents say, we're here to answer in the public interest. And this is an organ of state discharging a function in the public interest and must continue to function in the public interest. And that's the context in which we make that submission as to remedy. My Lords, unless the court has other questions in our direction, we would submit simply that prayer 3 in the review of the disciplinary action be dismissed with costs, and that prayer 3.1 in the main application, 3.1 be granted, the declaration of invalidity, but that there be a suspension either as prayed for by the SABC or as we submit. And we ask also the court to express a view about the powers of the minister to extend the appointment. And we submit that even in respect of the main application, there is in fact no case made out for any special cost order. In fact, that's important because that is also sought in the notice of motion. My Lord will see that in the notice of motion at paragraph 6, if I'm correct, the order is sought against the minister personally to pay the costs on a punitive scale. In the personal capacities, you'll recall, my Lord, in this application, she cited in a kind of odd way in that she's both the 11th respondent in her official capacity and the 18th respondent in her personal capacity, and they seek a cost order against her in the notice of motion. But in the founding affidavit, my Lord will find at page 75 of the founding affidavit, paragraphs 215 to 217, where the justification is given for a punitive cost order against individuals in their personal capacities, that zilch is said about the minister. Nothing. And therefore there can be no order granted at all. In any event, her conduct here may have been on bad legal advice. We get things wrong all the time. That's why we have appeal courts. My Lord, there is no reason to grant a punitive cost order against the minister because she got it wrong. Yes, we understand that they have abandoned that cost order. They just didn't say it in the main address. Otherwise, I wouldn't have had to say it. But we submit that anyway, it wouldn't fly. So those are our submissions, my Lords, unless there are any questions.
I've got no further questions to you, Mr. Motsoeneng. Thank you so much.
I wonder if I could just give a Lordship a reference.
Yes, you may.
That case which I incorrectly attributed to Mr. Justice Rogers was in fact the Booth case, the suspension, not the Kelly case. And the Kelly case, the reference is 23 ILJ 2035. It's in the Durban Labour Court, and in particular paragraph 29 of that judgment. It's Kelly versus Busisiwe Kanyile and others. I think that's the adequate reference, yes, the ILJ.
Thank you, Mr.
Might I beg an indulgence to address you after lunch for about 2 minutes on issues which have arisen from a learned friend's addresses pertaining to the public protector, which we would just like to clarify the related matters of interpretation.
Yes, Mr. Labuskaghni, Mr.
Yes. May I ask that we start 2:15, just so that I can get back to my chambers, do some photocopying which I feel necessary, as opposed to 2 o'clock.
Yes, the court will adjourn and will resume at 2:15.